Misuse of Section 498A and legal way out. As we know that for Section 498A of IPC talks about that husband or relative of husband of a woman subjecting her to cruelty shall be subject to imprisonment for a term of 3 years and shall also be liable to fine. Cruelty in its wider sense means in this section that any willful conduct or behavior which is of such a nature that it compels a married woman to commit suicide or to cause grave injury to herself or poses a danger to her life, limb, or health, either physical or mental. It also includes harassment of a married woman when it is done with the intention of wrongfully forcing her or any person related to her to meet any unlawful demand for, say, any property or any other valuable security. In today's scenario, many women are misusing this law, uh, and as they know that it is a cognizable, non-bailable, and non-compoundable offense in India. According to a report of NCRB, out of 4,66,079 cases that were pending in the start of 2013, only 7,258 cases uh, in which accused were convicted, while in other cases either accused were acquitted or the cases were withdrawn. The conviction rate of cases registered under Section 498 IPC was also staggered low at 15.6%. Now have a look at let's have a look at important judgment in Sushil Kumar Sharma versus Union of India 2005. It is court observed that there have been many complaints that are not bona fide and have been filed with oblique motives. The court opined that merely because the provision is constitutional intra vires, it does not allow unscrupulous person to break personal vendetta or unleash harassment. In Preeti Kumar and other versus State of Jharkhand 2010, court said that there has been increasing tendency of implicating husband and or his immediate relation. uh, Hence, the court has to be extremely careful and conscious in dealing with these complaints and must take pragmatic realities into consideration while dealing with matrimonial cases. In Arnesh Kumar versus State of Bihar 2014, court laid down certain guidelines stating that arrest under this section must be made after reaching reasonable satisfaction and after conducting a proper investigation as to the genuineness of allegation. Social Action Forum for Manav Adhikar and other versus Union of India, Ministry of Law and Justice and other 2018. Uh, in this case, court made a modification in the direction given by it in Rajesh Sharma case. It said that court observed that it is impossible to arrest before report uh, before report by family welfare committee uh, has made this section ineffective in the direction with uh, respect to the constitution and duties of the family welfare committee has been declared impermissible. Direction pertaining to the section 498 settlement has been modified to include that if a settlement is arrived at, the parties can approach the high court under section 482 of the CRPC. The high court, keeping in view the law laid down in case of Gyan Singh versus state of Punjab, shall dispose of the same. uh, the so how can a man who has been falsely implicated in a false case under section 498 can do? He can file a counter case against his wife uh, under section 500 for defamation of Indian Penal Code. uh, he can even file a case under section 120B of criminal conspiracy or section 191 uh, for giving false evidence against him, and section 227 of IPC for violation of condition of remission of punishment, and section 506 punishment for criminal intimidation. Court in its recent judgment in concussion Kausar versus State of Bihar 2022 held that the following prosecution in the absence of clear allegation against the in-law would simply result in abuse of the process of law. So you can even file case for restitution of conjugal right if a wife has left matrimonial home and went back to live with her family under section 9 of Hindu Marriage Act. You can even mention all the terms and condition that she has to follow to start living with you once again. Thank you.